about to leave, already packing. Come with me, I'm not really asking. We'll get away to a place where we don't know. About to see the world in action, what we can be, life with no distractions. We'll get away, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free with me. Let's go, let's be free with me. Be free. Not looking back, eyes on the freeway, Bonnie and Clyde, a classic cliche. We're on the run, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free.
Good evening, everyone. It's Jim here at Tutor to You. Welcome to our first post-half-term A-Level Law live stream. We took a half-term off for a couple of weeks. Hopefully you had a chance to rest up and you're back fired up, full of energy for, I think we've got 6 A-Level Law live streams this half-term, running up to some festive editions just before Christmas. And today's topic, Judicial Precedent, and we have just one, a soulless presenter, which is Emily. So good evening, Emily.
Hi there.
Good to see you. I know you've dashed from your teaching, so it's been a hectic day, but hopefully for the next 30 minutes or so, I'm sure it will be a very fast-paced review of Judicial Precedent. So for those of you joining us live, welcome. If this is for you for the first time, well done for joining us. Use the live chat to have a go at the questions. If you're watching on replay or catch up, then please take the time, pause the video, give yourself a bit more time to have a go at the various questions. We've got a mix of activities, multiple choice questions and various other things to have a go at. I think, Emily, we're almost good to go. What do you think? Shall we make a start?
Yeah, let's make a start.
I'll have a go as well in the background. Can't guarantee I'll do very well as normal, but at least I'll have a go. So over to you, Emily.
All right. Thank you very much, Jim. All right. So today we're going to have a look at improving our judicial precedent knowledge. So this isn't typically a very interesting topic, so I'm going to try to make it as interesting as we can, starting with an activity called altered vowels. So what you're going to see on the next slides are key terms, key phrases from the topic of judicial precedent, and they've had their vowels changed to alternate vowels. So A might become U, for instance. All I need you to do is type what you think the key term is into the chat. All right, so what do we think? Let's see, fastest finger first. Who thinks that they know what this first key term is or could be. Remember those vowels are changed? Okay, fantastic. Charlie's had a go. Well done, congratulations. Yes, that was law report. Obviously, law reports are where all of the laws are contained that judges create. So when a judge writes a judgment, they will pop that into a law report, and all judges from across the UK will be able to access those to find out what laws they have to abide by from judges in courts above them. Let's have the next one. Okay, I will give you a hint with this one. It's a Latin phrase, and I'll give you brownie points if you can tell me the actual English translation of it. Let's see. Oh, fantastic. We've got one there. Yep, well done. I think these are some of my students, actually. Well done. Very proud of you. Yes, fantastic. Loving the enthusiasm there. Yeah, it was ratio decidendi. And I was just about to ask, thank you, Adam. The translation of that is the legal reason for deciding. This is the thing that the judge gives at the end of a court case, and they explain the reasons that they've come to their decision. Well done. Let's go on to the next one. Again, another Latin phrase, so same principle applies here. Tell me what you think the phrase is, and then you get brownie points if you can tell me the Latin translation of it as well. Oh, straight in there. Well done. Fantastic. Let's see if any more people guess it. And well done. And can anybody tell me the translation of that? To stand by the decision. Fantastic. Well done, Katerina. So this is the principle that judicial precedent is actually based on. It's the idea that judges stand by the previous decisions of other judges in the court above them or of the same court. Fantastic. Well done. Let's have the next one. Okay, this one's not a Latin term, but it is a key term. Yes, true to you, they are on fire tonight. Let's see if they get this next one. No clues for this one. Well done, well done, well done. Yeah, 3 in a row, correct. 4, 5, well done. Even tutor you had a go, well done. Yes, it is binding precedent. This is one type of precedent. There are 3 types. This is the only type of precedent that, as it sounds, is binding. And the form of binding precedent that you need to be aware of is that previous key term, ratio decidendi. It's the only part of a judgment that's binding, and judges have to follow that. Regardless of whether they agree with it, if it's a statement from the court above them, they have to abide by it. Let's go for the next one. Okay, I'm not given any clues for this one. Let's see who gets this one right. I think we should also give out brownie points if anybody can remember the date of this as well. Well done, Katerina. Yes. Yep. Well done, Charlie. Fantastic. Well done, Adam. Brilliant. All right. Has anybody got the date? Before I could even finish the question. Yes. Well done. 1966. This is the thing that allows the Supreme Court to avoid following its own precedent. They use the practice statement of 1966 to avoid it. And this is where they believe that the precedent that they've previously set needs changing. It's quite rare that they use it, but it does happen, obviously, and it allows for a little bit of flexibility in the Supreme Court. Brilliant, well done. Okay, we've got a 30-second challenge for you next. What you're going to do is you are going to list the courts that you can recall, but ideally separate them into civil and criminal courts, okay? Brownie points again if you get them in the correct order of the hierarchy. All right, so try on the left-hand side to write down a list of civil courts, and then on the right-hand side, criminal courts, or vice versa. All right, and then your extension activity is to state whether those courts that you've listed are classed as inferior or superior courts. Remember, the superior courts are the only ones that are allowed to set precedent, so that might help you with that. Let's begin the 30-second challenge. All right, let's see how you did. Wow, well done. Yes, good, Charlie. And criminal, yep, well done. Yes, good. Fantastic. All right, let's go on to the next slide and see those cases, see those courts. So on the left-hand side, we've got criminal. And on the right-hand side, we've got civil. Yes, well done. Oh, Adam even got the European Court in there. Well done. So yes, right at the top, you've got the European Court of Justice. One below that would be our final Court of Appeal. Below that is the Court of Appeal. You've obviously got the criminal division in the criminal side, and then the civil division in the civil side. Below that, the Queen's Bench division of the High Court is the only criminal court, but the High Court Ordinary and the other two divisions are civil divisions. Below that in the criminal court, you've got the Crown and the Magistrates Courts, and then finally the County Court at the bottom of the civil hierarchy. When you're talking about this hierarchy, bearing in mind you can get a full question on this. When you're discussing the hierarchy, you need to explain the importance of it. So you would, rather than just listing the hierarchy of the courts, you would explain that the higher courts bind the lower courts, and the lower courts are expected to follow the decisions of the courts above them. Some courts bind themselves as well. So for instance, the Supreme Court is supposed to bind itself unless it uses the practice statement. The Court of Appeal also binds itself unless it uses an exception, which I'm not going to tell you because that's a question later on. And also the High Court divisions bind themselves. But the others don't bind themselves, so they have a bit more flexibility. When you're doing this, you want to be referring to ratio decidendi, explaining which courts bind others, which courts bind themselves, and explaining the effect of the hierarchy. And if you want a bit of a brownie point, when you are writing an answer like this for your teacher or an examiner, you could pop in an Act of Parliament. Does anybody know the Act of Parliament that states that established the hierarchy of the courts? I'll be very impressed if you do. Yes, well done. Judicature Acts. Fantastic. Does anybody know the date of those? Perfect. Well done. All right. Well done, Louis. Yes. So if you want to get yourself some brownie points with the examiner, you mentioned that the Judicature Act largely established that court hierarchy. Fantastic. Well done as well, Adam. All right. We've got some statements now. I know, it is fantastic. I agree. We've got some statements now. You simply need to state, yes, well done. You simply need to state which of the statements are correct, A, B, C, or D. So you don't need to type out the actual answer. You just need to state in the chat A, B, C, or D. And there is only one correct answer for each one for this topic, or for this activity. All right, so when you're ready, A, B, C, or D, please vote now. Thank you, Adam. Okay, we've got one answer. Okay, not a consensus yet. Let's see. Okay, more people saying C. Let's just wait for a couple more answers. Okay. All right, let's see what the answer was. All right, the only one that's not essential is obiter dicta. It is important. Other judges can follow it if they want to, but it is only binding precedent. So yes, well done. So the clear court hierarchy is absolutely essential. Judges need to know what courts they're bound to follow. Law reporting is obviously essential. They need to know where to find those judgments. And then ratio decidendi is absolutely essential because that's the only one that is actually binding precedent. That's the part of the judgment that judges have to follow. The obiter, even though it's included in a judgment, isn't essential. It's other things said by the way. It's hypothetical situations that judges might explain just to sort of help another judge out if the facts of the case are similar to that instead of the facts of the current case. All right, well done. Let's see if you can get the next one. Which of the following statements is true? A, B, C, or D? Again, there's only one correct answer. Untrue. Yes, sorry. Thank you for correcting that. Which one of the statements is untrue? I think I said true there. Okay, Charlie, we've got you. First person's always the brave one. Okay, Louis gone for C. Katarina's gone for A. All right, okay, well done. Not complete consensus here. Let's see what the answer was. All right, well done, Cole. All right, thank you for joining us. All right, C. So inferior courts cannot establish precedent. These are the county courts, they are the magistrates and the Crown Court. All right, those courts do not establish precedent, then they simply follow the precedent from the courts above them. All right, well done if you got that one correct. All right, let's see about this one. Which of the following is not an inferior court? This one should be easy. So A, B, C or D, which of those is not an inferior court? You meant C. Of course you did. Okay. Bit more of a consensus on this one. Well done. All right, let's get the answer. Yeah, congratulations if you said Supreme Court. The Supreme Court obviously is the highest court in England and Wales, and therefore it's not an inferior court, it would be classed as a superior court that can set precedent. Well done if you got that one correct. Next, which of the following isn't a criminal court? So the previous activity should help you with this. You separated your courts into criminal and civil. Let's see what we think. A, B, C or D. Which is not a criminal court? Right. Charlie, you're definitely one of the brave ones. I was going first. Well done. Okay. Not saying which one's correct just yet. But we have got most people agreeing with A. Yep, 4 for A so far. 5 for A so far, including due to you. Thank you. Okay, thank you, Cole. All right, let's see if you were correct. And yes, of course you were. The county court is just a civil court. It is not a criminal court. It doesn't deal with criminal cases, unlike the magistrates or the Crown Court. And then the Supreme Court obviously deals with appeals for criminal and civil courts. So that would be part of both. Next, where would you find the ratio of a case? It's a good idea to copy everyone else. They seem to be doing quite well. Where would you find the ratio of a case then? A, B, C or D? Law reports, law magazines, a statute, which is an act of parliament, or a chamber's newsletter? I think you're going to find this one easy. Again, most people going for A this time. Well done, yes. Okay, fantastic. Yeah, it is law reports, such as All England law reports or others that I'm not going to name because, again, that's a question later on. Yes, these would be included in a law report. Well done. Which of the following wouldn't be found in a law report, though? A, decisions of earlier courts. B, academic commentary on the judgment. C, the name of the case. Or D, the judgment. Right, Charlie's gone for B. Ooh, we seem to be a bit more hesitant on this one. If you're struggling, do it by process of elimination. Think what has got to be included and then work your way down. Okay, yeah, people are a bit more hesitant about this one. Well done for having a go anyway. All right, well done if you said B, which is everybody, so fantastic. Yeah, academic commentary on the judgment just isn't included, but previous decisions are included because that helps the judge to come to a decision, so it might actually form part of the ratio. The name of the case is obviously included, and then the judgment, of course, has to be in a law report. That's what is in a law report. Fantastic, let's move on. Which of the following courts is only bound by itself, but not any other courts? All right, what are we thinking? Which one of the courts is only bound by itself, but isn't bound by any other court? All right, we've got 3 Bs so far. All right, most people gone for the Supreme Court. Okay. That is right. So it is at the top of the hierarchy. Therefore, it is the Supreme Court. It's the only one that's only bound by itself. Because it's at the top of the hierarchy, other than the the European Union law, which obviously isn't as important anymore, the Supreme Court is not bound by any other. Oh, hi, Lila. Thank you for joining. The Supreme Court is not bound by any other court other than itself. All of the courts below it are bound by the Supreme Court and any others above it, but the Supreme Court is the only one that's only bound by itself. Well done. All right, the High Court wouldn't usually be bound by which of the following decisions upon the same point of law? A, B, C, or D? So that's a really good question. There was talk about the exam boards considering this, but as it stands, nothing's changed. The Supreme Court is still bound on European Union matters until all of the EU law has gone out of our UK law. What's going to happen eventually is that we are going to rewrite all of the EU laws that we want to still follow into UK law. But until that happens, what if anything still applies to us? Yes, we still do have to follow it. However, if anything changes within 12 months of your exam, you follow the 12-month rule. So if something's changed within 12 months, you don't have to be aware of it and you can still use the previous law, all right? So don't worry too much about things that have changed in the past year for your exam. Right, back to this. Let's get the answer up for this one. So the answer for this one was D. A decision of the Crown Court would not have to be followed by the High Court. Well done, most people got that correct. Fantastic. All right, I believe that this is the last one for this round. Which of the following can the Court of Appeal not use in order to avoid a precedent? So if the Court of Appeal get a case, I should say, whereby they should follow a particular precedent to come to a decision, they have options available to them to avoid following that decision, but which one of those is not a decision or is not an option to avoiding the decision? Okay, got a couple of answers so far. I won't say whether they're correct just yet. Think about it, it's coming from the courts below up to them because they're going to hear it on appeal. No worries, Katerina. It's a totally valid question. I think a lot of people would be interested in knowing the answer to that. All right, let's get the answer to this one up. So congratulations if you said D, the practice statement. It is only the Supreme Court that can use that. The Court of Appeal can use overruling because obviously we've... Oh yes, sorry, we've got a bonus question. The Court of Appeal can use overruling because they can overrule the decision of the High Court or any of the courts below them. And then they can also use distinguishing to distinguish from the earlier facts of another case. And then obviously they've got the young exceptions available to them as well. All right, which case was distinguished from that of Brown? Speaking of distinguishing, I think this one's going to be an easy one for you, but let's see. All right, Charlie's gone for B, Louis gone for C. Let's see what everybody else thinks. Charlie's also gone for C. And Adam's gone for C now. That's a very good way of thinking about it. It must have been after 1995 if it distinguished from the case of Brown. That's true. All right, most people have gone C. Well done. Yes, that is true. Wilson distinguished from Brown, whereby the ratio was that GBH and ABH injuries can't be consented to if they are caused by sadomasochistic practices. Wilson distinguished from that by saying that what Wilson and his wife were engaging in wasn't S&M, it was a form of tattooing or bodily adornment similar to tattooing. What he'd actually done, if you don't remember the details of the case, is he'd branded his wife's buttocks with his initials at her request. Interesting case. All right, we've got a true or false round now, so you can just type in true or false or T or F for the answer. Yes, bodily adornment. I know, very strange. There are some strange people in the world. So in this round, you're going to simply say true or false to the statement that you see on the screen. So, number one, a judgment may contain more than one ratio. Do you think that that is true or false? Ooh, are we struggling with this one? All right, Charlie's gone for false. Layla, false, okay. Louis, false. Ooh, we seem to be a bit hesitant to answer this question. Most people think false, but it's actually true. It can actually make it very difficult for a judge in a future case to find the relevant ratio that they have to find. So you could actually link this into the evaluation if you wanted to. Sometimes there's more than one ratio, and that means that the judgment is pages and pages long, and it's not clear as to which ratio you're supposed to follow. And yeah, like I said, it means that judges in future cases of similar fact will struggle to find the ratio that they're supposed to apply. And it can also make it difficult for barristers and solicitors to figure out what the likely outcome of the case is. So yeah, use that for revision. Use that for evaluation. Let's do the next one. So true or false, the Supreme Court is the only appeal court in England and Wales. What do we think? True or false? Charlie's gone for false. Think about your hierarchy. Who's also gone for false. Okay. Most people gone for false so far. Good memory. All right. Well done. That is false. The Supreme Court, of course, is not the only appeal court in England and Wales. You've got the High Court that can be appealed to. You've got the Court of Appeal, obviously, that you can appeal to. And then from the Magistrates' Court, you can even appeal to the Crown Court. So yeah, it's not the only Court of Appeal in England and Wales. It's the final one, but not the only one. Next, not all judges may agree with the outcome of the case. So if there's multiple judges, are they allowed to disagree with one another? Or do they have to come to a consensus? What do we think? True or false? Charlie's gone for true. Also Louis. Oh, hi Millie. Cool. Well done. Okay. Yeah, Adam. All right. Yeah. Most people are getting this correct. Fantastic. In fact, everybody's gotten this one correct. Yeah. Not all judges have to agree with the outcome of the case. Well done to you as well. You're going to have a fantastic knowledge of judicial precedent after this. No, not all judges might agree with the outcome of the case. In fact, do I have time for a question? You are on fire. Does anybody know what it's called when a judge writes another judgment that disagrees with the other judgment that the majority of judges agree with? Anybody know? I'm going to be very impressed with whoever gets this. Yes, well done, fantastic, Louis. It's a dissenting judgment. So yeah, it's true, not all judges might agree with the outcome of the case. In fact, they might write a dissenting judgment explaining why they disagree. Oh, well done for correcting your spelling. There's no E in judgment. Yes, well done. And Adam got that right as well. Well done. All right. Persuasive precedents can bind inferior courts. True or false? Persuasive precedents can bind inferior courts. True or false? What do we think? Oh, I thought you'd be straight on this. Oh, Charlie is. Okay. All right, we've got Charlie, Louis. Let's see. So Charlie, Louis, Lila, all gone for false. Okay. I won't say whether that's true just yet. I should say correct. Anybody else want to give their answer before we reveal? All right, let's go ahead and reveal the answer. Well done if you said false. All right. So persuasive precedents cannot bind inferior courts because persuasive precedents do not bind anybody. They're persuasive, they're not binding. Next, a judgment will contain both ratio and obiter. True or false? All right, Charlie's gone for true. Good. Adam, true. Well done. Oh, Louis says false though. Well done, cool. Yes. Yeah. Well done, yes. This is true. Well done. Although the orbiter isn't necessary, and it's not binding, it's still usually included in a judgment. Yeah. All right, we've got a bubble quiz now. This one's a little bit different. There's not necessarily only one correct answer. In fact, the amount of answers that can be correct range from 0 all the way to 4. All right, so you just need to state A, B, C, or D, or any combination of those letters. All right, so A, B, C, or D. There can be 0 or 4 answers correct. All right, so let's start with the first one. High Court, Queen's Bench Division is bound by which courts? A itself, B the Supreme Court, or C the Court of Appeal, or finally the County Court, D. So you're only typing the letters that you think are correct. And it might be that all 4 of them are correct, it might be that 3 of them are correct, it might be that none of them are correct. What do we think? Right? Yeah. All right, pretty much everybody said B is correct, for definite. Most people have said C and A as well. A, B, C. All right, let's reveal the answer. Well done if you said A, B, and C, which is pretty much everybody. Well done. So the High Court is bound by, well, the High Court Queen's Bench Division is bound by itself, the Supreme Court, and the Court of Appeal, the Criminal Division. Well done. Number 2, which court can hear both civil and criminal cases, but in the same division? You still tried, two of you. It's the effort that counts. So which court can hear both civil and criminal cases in the same division? All right, remember the answer might be 1 out of the 4, 2 out of the 4, 3 out of the 4, 4 out of the 4, or none out of the 4. Although most people have gone with B so far. All right, let's get that answer up. Congratulations if you said B, which was everybody. Yeah, Supreme Court is the only one that can hear both criminal and civil cases in the same division. The Court of Appeal would be able to hear criminal and civil cases, but there's 2 divisions for it. There's obviously the criminal division and then the civil division, and there will be different judges within each court. Number 3, which of the following are well-known law reports? The one that I mentioned earlier is not in here on purpose. Ooh, struggling with this one. This is because with my students, I only use the one that I mentioned earlier. And don't panic if you don't know this. It's not essential to know lists and lists of law reports. One example is usually enough. All right. Oh, Adam's gone for all of them, just to be safe. It's probably a good strategy. All right. Let's see which ones of those are correct. Well done if you said A, B, and D. A-level law reports are the only ones that aren't actual law reports. They're made up. I mean, I'm sure you could maybe get some for A-level, but they are not real ones that judges would use. Let's move on to number 4. A decision on a point of law that's never previously been decided creates which type of precedent? New, original, binding, or ordinary? What do we think? Charlie's gone for A. Louie's gone B. Oh, hesitant again. Might as well give it a go. The worst that can happen is you're wrong. All right, Adam's gone for B as well. Okay, Phyllis has gone for A and D. Tutor, you have gone for B. Congratulations, well done if you said B. Original precedent, yeah. You can't call it new precedent even though I suppose it is. The actual term for it is original precedent. Well done. Number 5. If a superior court changes the decision that's made in a lower court, what is that known as? As you can imagine, there's only one correct answer with this one. All right, Cole's gone for D. All right, Charlie's also gone for D. Getting a bit of a consensus now with Louis going for D as well. And Adam gone for D. Right. Seems like everybody's gone for the correct answer, overruling. Yes, well done. And Layla, well done. All right, we're going to do 4. Give me 4 advantages of the precedent. Of the system of judicial precedent. All right. So we've got the last 2 activities now. This one's going to focus on the evaluation, so we're going to concentrate on the positives. We're going to look at the advantages of the system of precedent. So all I want you to do is type in something good about judicial precedent. So what is the benefit of it? What are the advantages of it? And I don't need, an essay or a paragraph. It's fine for you to just give me bullet pointed answers. So off you go. Give me some advantages of judicial precedent. What are the pros of it? You could even compare it to law made by Parliament. Think about why Parliament don't necessarily make all of the laws. Yes, well done. I was just about to say, think about what judges have that Parliament don't. Yes, judges have legal expertise. Parliament don't necessarily. I mean, there are some members of Parliament like Keir Starmer who used to be barristers, so they will have an understanding, but it's not the case that every MP has a legal background, and so judges with their expertise are possibly the best people to create law. It's also creating consistency. Yeah, well done, Louis. And it helps judges decide because we've got that system of precedent. Thank you for putting that on the screen. We've got that system of precedent whereby the decisions made by higher courts are kept in nice, neat, organised locations, in judgments, in law reports, and all judges and barristers and solicitors can access those easily. It also does save Parliament time. Parliament don't have the time to create and fix every law that's necessary. Judges can do that straight away. And it's also authoritative. Yeah, that's true. It's made by judges who have a lot of experience. These are the people who have, had at least 5 years minimum experience as a barrister or solicitor, usually 7 before they become a judge. And even then, they can't make precedent until they reach the higher courts. So they have a lot of expertise by the time they're able to make precedent. Well done. I'm impressed by how much you remembered there. All right, this is the last activity and it's called the big reveal. What you have to do if you haven't done this one before is figure out what is hidden behind the question mark before all of the clues are revealed. So there are going to be 5 clues. The first one is that this is a statute, so it's an Act of Parliament that was passed in 2005. That might help a lot of you already. Let's go with clue number 2. It established a new court, and even though it established a new court and it was passed in 2005, the court itself didn't actually open until 2009. All right, Louis' gone with an answer. Let's keep going. I'm not going to say whether that's correct or not yet. This court sits within both hierarchies, so the criminal and the civil division. So this court that was, statute that was passed created a court that sits within both court hierarchies. All right, we've got more people with answers. So lots of people saying the Constitutional Reform Act of 2005. Again, I'm not going to say which one's correct. Clue number 4 is it had significant implications for judicial precedent because obviously it massively changed the court system. We moved from the House of Lords being the final court of appeal to a new court being the final court of appeal. All right, more people coming with that 2005 Constitutional Reform Act. Let's have the 5th and final clue. This new court sits in Parliament Square, and this new court is the Supreme Court. All right, and I think, yes, most people got that correct, and I'm really happy about that. Well done. The Constitutional Reform Act 2005 established the Supreme Court, and that basically took over the old House of Lords, which was the final court of appeal before then. But like I say, it didn't actually start hearing cases until 2009. All right, I think that is the last activity.
Wow.
Yeah.
I am absolutely blown away by the speed and accuracy of the students joining us live. I'm sure the students watching on catch up and replay will be equally as impressive. But what do you think to that? That was amazing, wasn't it?
Fantastic. Yes, very impressed.
So quick.
On the ball.
It made it really easy for me because I could just copy what they were writing down.
Yeah,
Fantastic.
Well done,
Too right. Well, well done to you, Emily, for a fantastic effort there, a supreme effort, to borrow the term of the top course in terms of delivering that session. And you've absolutely rattled through so much top content, really useful stuff on judicial precedent. So many thanks to you for doing that.
Not a problem at all. I enjoyed it.
If you enjoyed the session, either live or catch up on replay, give Emily a thumbs up on YouTube. Come on, she deserves it for that amazing session. Don't forget, also, you can go to tutor2u.net/live to replay this and all our previous sessions. I think there's about 15 now we've done this year. Loads of stuff that might be really useful for if you've got some mocks or assessments coming up, maybe later this term or just after Christmas. Don't forget, this is a regular date, Tuesdays at 6:30 for our law session. All the remaining sessions for this term are now lined up. We'll be adding the ones post-Christmas very soon too. So please do make use of that, spread the word, and well done. So from Emily and I, until next week, have a great week, and we'll see you later.
Bye, everyone. Well done.